Hello, everyone. My name is Emily Tyson-Shu. I'm one of the estate planning and probate attorneys at Beresford booth. Today, we're going to talk about demystifying non-intervention powers so as to understand why probate processing in the state of Washington is not daunting. This is actually a follow-up topic from the presentation done by our other probate and estate planning attorney last month by Joshua Curtis about the general probate process. So if you're interested in about the general probate process, please feel free to go to our website, and there are a lot of videos for you to view. So from time to time, I've gotten a lot of questions from people wondering if probate in Washington is cumbersome and or time consuming. It's understandable why people have this type of impression, as legal proceedings in general are time consuming and expensive. However, this is not necessarily the case for probate in Washington, and this is why we're going to talk about non-intervention powers today, so as to help you understand why probate is not so daunting in Washington. And today, we're going to cover two items. One, what are non-intervention powers? And secondly, what actions can I take to make it easier for my personal representative? So, what are non-intervention powers? Non-intervention powers are statutory powers specified under RCW 11.68.090. So generally speaking, if a family member passes away, usually someone will come forward working with an attorney and evaluate whether probate is needed. If it makes sense to open a probate, the attorney usually will help the person getting appointed as a personal representative. And usually the attorney will also have the discussion with the personal representative, family members, oftentimes, on the topic of non-intervention powers and evaluate whether it's applicable or whether it makes sense to petition the court to get, the personal representative granted with non-intervention powers. So let's take a deeper look or closer look at the statute. So what does it mean exactly? So RCW 11.68.090 provides that under subsection 2A, yes, it provides that a personal representative with non-intervention powers may act without an order of the court and without notice to, direction from, approval by, confirmation by, or intervention of any court. Sorry, I forgot to click on this page so that you can also take a look at the statute along with me. So we're just looking at the subsection 2A. So what does it mean? It means, in layman's term, the personal representative with the non-intervention powers doesn't need to come back to the court for certain actions that the person intends to take for the administration of the estate. So in other words, it saves time, saves energy, and of course money, because the personal representative doesn't need a lawyer's help to draft up the legal proceedings or pleadings to petition to the court or to make any arguments to the court with that power. However, as the saying in the movie of Spider-Man, with great power comes great responsibility. So a personal representative with non-intervention powers still has the same duties, restrictions, and liabilities as a personal representative without the non-intervention powers. And further, as we can see under the subsection 2C, a personal representative with non-intervention powers must exercise a discretionary power in good faith with honest judgment and in accordance with the terms and purposes of the probated will and the interests of the beneficiaries. Meaning that if a personal representative is granted with non-intervention powers, like a superpower, similar but not exactly the same, but with that convenience in mind, the personal representative still has to act with good faith, honest judgment, and in the best interests of all beneficiaries. So we talk about those powers cover certain actions that a personal representative would like to take for the administration of the estate. And then you might wonder what actions are covered. So those actions are listed also under RCW 11.68.090. As you can see, it's a long list, and you are welcome to take a closer look at all the powers. However, from my experience, I think the powers listed under subsection 1C, actions listed under subsection 1C are the most commonly seen, including the power to mortgage, encumber, lease, sell, exchange, convey, assign, and otherwise transfer the decedent's real and personal property. So the decedent means the person who passed away. So it is, for example, as you can imagine, if someone passed away in your family, this deceased person, the decedent might have left, some assets, usually a house, maybe a couple bank accounts, some cars, things like that. And a probate is a legal process to allow the title to be transferred to the beneficiaries. And the process of transferring, for example, maybe the personal representative needs to sell certain real property, given the circumstances, or, towards the end of the probate, the personal representative is ready to transfer the title to the beneficiaries. And all these actions are covered by non-intervention powers. So if the personal representative is granted with non-intervention powers, this personal representative doesn't need to come to the court for the court's approval to do all these actions. So non-intervention powers are not just granted by the court automatically in some situations. Now that you know what powers a personal representative can be equipped, you might be interested in knowing what you can do to make it easier for your loved ones as personal representative for your estate in the future. So what actions can I take to make it easier for my personal representative? One thing I will recommend is you can think about, preparing your own will. So there are pros and mostly pros, and here's are the reasons why. First, you can name the person or persons who you'd like to appoint as personal representative for your estate. By doing so, you will know that your estate is going to be administered by someone so it wouldn't be administered by someone to your surprise. Because in some situation, if there's no one is named or no one comes forward to petition to act as a personal representative, a creditor potentially can petition the court to administer the estate. And the second reason why you can consider to prepare your will is that you may, for example, the topic that you just went through today, you may specify your wish for the court to grant non-intervention powers to the person or persons named in your will as personal representative. So that okay, whoever's going to help you, to help administer your estate, well, likely to be granted with the non-intervention powers, because now that the court would know your wish in writing. Third, and that we didn't talk much about a bond today, but I think it's equally important as the non-intervention powers, is that if you prepare your own will, you may also specify your wish for the court to waive the bond for the person or persons named in your will to act as a personal representative. As you can imagine, you will potentially save some financial costs down the road. So I believe that concludes my topic today. If you have any questions, if you would like to know more about non-intervention powers, or if you're interested in creating your own will, please feel free to contact our firm at any time. I hope you're enjoying the topic today. Thank you.